All right, guys. So good morning again. At this time, particularly early morning, 9:30. I want to welcome you all. And this time, before I begin, I just want to tell you that last session, apparently, I forgot to switch back to screen share after I switched a screen. So please do make sure that you inform me if, in fact, you don't see what I'm referring to on the screen. That way, we'll have it for posterity. I am going to get this up. Let's go. There we go. All right. So without further ado, let's get cracking. We're doing a morning refresher today. And I'm going to touch on two topics particularly. I'm going to talk on good faith and anticipatory breach. And per usual, you know, my little ramble at the beginning. Why is this at 9:30, not the usual 10 a.m.? I have a dentist appointment at 11:30 a.m. Oh, yeah. I figured that was as good as any way of beginning our little session today. So I'm going to jump right into it. Just as an aside, I suspect that this particular talk will be about 40 minutes in duration. It will be about 10 or 15 minutes shorter than normal. This is really just touch points and refresher, but we will all experience that together. Let's move on. So almost every one of us is aware that in 2014, the Supreme Court came out with a new decision called Bassin and Harnu. And I actually have a personal story that relates to this. And I should be somewhat careful in how I say it, but I knew one of the parties, at least tangentially, I knew one of the parties to this litigation. And there was quite a bit that I learned about what not to do in business based on my relationship to one of those parties. And as it turns out, oh, hold on one second, please. I think we're having internet connection issues. Hold on, please. Sorry. I apologize, guys. I'm just going to make sure that I have a fluid connection. Hold on. Bear with me, please. Sorry, one more second. Are you guys here? Can you hear me? Can someone just confirm?
Confirmed. You sound loud and clear.
Thanks. Okay, I just switched to a better internet source. So someone I knew was related to the Bassin Harnu crew, and actually was part of the good guys. And they taught me really everything not to do in business. And I find it incredibly ironic that I currently have to cite his name every time I'm trying to tell someone to act in good faith. Regardless, the Bassin and Harnu effectively recognized that good faith is a general organizing principle of Canadian common law. So what does that mean? Well, that basically means exactly what it says. If you have a contract, then the courts are going to assume that everyone was going to act in a manner that furthers the contract as a collective whole. And that sounds like a bunch of mumbo-jumbo gibberish. I can hear it. And in fact, it probably was, because not many people understood what the terms general organizing principle of Canadian common law meant. In fact, most people believed that following Harnu, there's now just the obligation to act in good faith in everything you do. And that isn't necessarily entirely true. And we've had some advantage now because Bassin and Harnu came out in 2014. It has now been 6 years. And the advantage of having a Supreme Court judgment is that it starts getting used in cases over the course of years. And indeed, Bassin and Harnu has been used in certain cases over the years. And let's take a look at what has happened to it since. So since Bassin, people have tried to use good faith and said, hey, you have an obligation to use good faith in your contractual dealings. And in some cases, as with all aspects of law, the courts have been utterly wrong in their interpretation. By the way, no one's corrected this particular case. It's still standing. But, I mean, it's just a ludicrous way to interpret Bassin and Harden. So Westwood Mall holding happens, this is what happens. A developer gives a price reduction to a whole bunch of people. So they sign a bunch of agreements, purchase and sale, brand new, and then they give like 3 or 4 of them price reductions. And Capilla comes up and says, hey, I didn't get a price reduction. And the developer says, no, we have a contract. We have a contract. I'm not giving you a price reduction. Why? Because we have a contract. Done. But Capilla sues. And Capilla says, hey, you know that whole Bassin and Harden thing? Well, this developer is not acting in good faith because he is treating people arbitrarily and in absolutely at their discretion. And we want the courts to enforce lowering my agreement of purchase and sale as well. And unbelievably, the lower court said, yeah, that makes sense to us. Sure, we don't really care what's contained in the contract. The developer's just acting capriciously, and whereas they're giving reductions to everyone else, they're not giving it to this guy. That doesn't seem fair. And so the developer, of course, appealed. And unbelievably, not the Court of Appeal, but it was appealed to the Superior Court because it was originally a small claims court decision. The court found that, and I'm going to read this, the developer's insistence on being paid the stated price in the agreement when it had reduced the price for other purchasers was a failure to act honestly in the performance of the agreement and breach of duty of fair dealing. Honestly, I'm just going to get rid of this. Honestly, I am appalled by this decision, as are most lawyers that I know in real estate. This extends Bassin to the idea that not that you have to interpret a contract with good faith, but that everyone has to act fully fairly at all times to everyone. And you can see that expansive reading from the court. And what it says, by the way, to litigants is always throw good faith into your arguments, because who knows, you may have a stupid judge that looks at this and says, yeah, okay, well, I can cherry pick. I can reach up from the bench and interpret contracts wholly differently than what the parties intended. And you may be successful. I mean, this is truly one of the stupidest decisions. This is over. This is me just kind of rambling, but this is truly one of the stupidest decisions I've ever seen a court make. I mean, to interpret a strong contract that has definite terms and basically say, oh, by the way, you're acting differently to other people. Well, we all act differently to other people. You're allowed to do that. Good faith should not, because in this case it did, should not mean that it governs your entire life. It's an overriding principle of a way to interpret a contract, not to interpret people's behavior generally. And in fact, what I'm saying has since been really the law of the land. This here is really an aberration. I really don't think if you were to bring this forward to a judge, any judge who understands law would ever interpret it this way again. And in fact, the court cases since that, and before that, by the way, this particular case I'm about to bring up right now is before the one I'm going to bring up after is post. They've established what is, I think, a pretty clear interpretation of how Bassin is now used. And the reason I'm highlighting this particular case, 233-6574 Ontario, is because they made particular note of how good faith should be applied to a real estate contract. I note, by the way, that the previous case did too, but this one here specifically speaks to real estate contracts, and you'll see the part in bold. And what the judge said is, where there are commercially experienced buyers and sellers in a discrete one-off transaction, the level of contract adherence would not be expected to vary from the strict contractual terms. Given the relationship with the vendor and purchaser in a discrete real estate deal, good faith meant sticking to the contract, not bending the contract, even just a little bit to one side's will. In other words, good faith is in fact abiding by the terms of the contract. And I really like the clarity that this had brought to the law, but of course, if you take a look, this date here is 2017, this date here is 2016, and as a result, we basically have two very conflicting decisions. One that says, hey, good faith can force someone, even in a binding contract, to look at their entire actions as a person and as a company, go well beyond the contract, remove themselves from the contract, and allow a judge to determine whether or not you're being fair in life. Obviously not right, but was the decision. And the other that says, look, you have a duty in a real estate relationship. It isn't like an employment relationship where the principles of good faith need to come in over and over and over again, and the contract is largely undefined, and it's not a one-off where people understand all the permutations of a deal. In a contract like real estate, where it's one-off and everyone understands the terms, good faith has much less applicability. And in fact, thank goodness, I'm giving this talk after this ridiculous case, and I'm now able to point to what I think is becoming the seminal case since Bassin on good faith, because it really sets out an elaborate test. By the way, the same court that found the previous ridiculousness. And I distilled this really into 4 different points. And this is a good way, if you want to think of what Bassin means in real estate, time development group is a good case for that. Because in that instance, the court found 4 things. 1, it found that Bassin meant that the common law of contract includes an organizing principle based on the recognition of good faith as an operative component in the performance of contract. But it's only an informing principle. It's not a standalone duty or a rule. Now remember, what happened here is that there was a standalone rule or duty. There was a standalone duty that the developer, separate and apart from the contract, because he was acting otherwise in different contracts, that he would therefore have to act that same way in this contract. And that means that it was a standalone duty or rule. And what the court says here is no, it's only an informing principle. It's not a standalone duty or rule. 2, the court found that in performing a contract, a contracting party should have appropriate regard to the legitimate contractual interests of the contracting party, but this does not necessarily require one party to act to serve another party's interests. So, for instance, if in fact you are, say, 5 minutes late delivering a deposit, and we all know that if you deliver a deposit late, let's say the agreement says if it's not delivered, the deposit's not delivered, this agreement shall be null and void. If you're 5 minutes late, and the other side says, sorry, you're 5 minutes late, we're no longer accepting this. Does that then mean that the party who was 5 minutes late can go to court and say, hey, they're not acting in good faith? They're not actually acting in a manner that befits the law? And the answer is no. That's not the way the courts interpret this. Yes, you have to have regard to legitimate contractual interests of the other contracting party, but they don't need to act in your interests. So what are the legitimate contractual interests of the contracting party? Well, it's to abide by the strict terms of the agreement, which says that a deposit has to be in 5 minutes before that. Thank you very much. The third point was that although it's not supposed to undermine the other party's interests, good faith performance does not engage loyalty to the other contracting party or a duty to put the other parties first. In other words, this isn't a fiduciary duty. This isn't something where you have to put their interests before your own. You are perfectly entitled to act contractually in your own interests. And last, the development of the principle of good faith is not an opportunity, and this is really just kind of striking down the previous case. The development of the principle of good faith is not an opportunity for ad hoc judicial moralism or to be used as a pretext for scrutinizing the motives of contracting parties, which is precisely what happened in Westwood Mall Holdings. And as a result, what good faith is good faith is something which will not reverse the strict terms of a contract. All the things you knew about a real estate contract before Bassin, true today. If, however, people start using the contract in what is effectively, I guess, bad faith. I'll give you an example. So let's say someone were to say, oh yeah, well, don't worry, time is arbitrary. Yeah, okay, you want to be late with the deposit. You know what? I understand that you have a 5 o'clock deadline on the deposit, but you know, you can bring it in at 5:30 as long as you go ahead and you waive this condition at the same time. Go ahead and do that. And then they bring it in at 5:30 and suddenly they turn around and they say, hey, you actually brought it in post time. We are absolutely going to deny you the ability to consummate this deal. Thank you very much. Well, at that point, A, they're stopped from doing it. That's just a basic legal principle. But now you'd be able to also rely on the doctrine of good faith. And you'd be able to say, thank you very much. You know, you aren't acting in good faith. You're not acting in a manner that befits the contractual relationship between the parties and allows them to pursue the legitimate contractual interests of this agreement. And that is kind of where good faith has now sat. Yes, there is an organizing principle, but that organizing principle does not extend to your person, does not extend to your larger actions as it did in this particular Westwood Mall Holdings case, and applies only to the way that the courts will interpret the activities of the parties within the confines of that contract. I believe time development and these 4 principles are really going to become the key organizing principles around BASIN, and that all future claims or cases that rely on BASIN are going to engage in this test or something pretty similar to it at the end of the day. So that's what I have to say about good faith since BASIN. Does anyone have any questions about that before I meander on and start talking about something else? Nope. Good. Give me 1 second. All right. Let's get back to business. So now we're going to deal with a different concept, one that you may not be familiar with, but definitely the lawyers are. Actually, to be very frank, some lawyers aren't, but those aren't the lawyers that you should be using for your real estate transaction. And this is the idea of anticipatory breach. So anticipatory breach occurs when one party, and this is completely different than good faith, by the way. This is a different subject matter. We're moving on. When one party, by their language or by their express conduct, allows another party to say, well, you simply are not going to abide by the agreement. So as we're aware, when we sign an agreement of purchase and sale, generally, we have 3 months, 4 months until it finally concludes. A lot can happen in that time. The buyers and the sellers interact. What happens if the buyer was, say, like in the past couple of months during COVID, locked into an agreement and starts telling you, I can't do this. I can't do this. I'm not going to be able to close. They're not saying I'm having difficulty. They're saying, I can't. What happens? Are you forced to wait around for 3 months, 4 months for this to finish before you can move on with your life? Well, if there are actions or words that inform the other side that the offending party will not be concluding a transaction, if the breach goes to the root of title, meaning that they are not going to provide the money for the purchase, or they're saying, thank you very much, I'm not going to sell you my property. And if you have written to the other side or brought it to the other side's attention and they have not responded that they are proceeding forward, if they actually confirm that they are going to breach, then you are allowed to claim anticipatory breach. An anticipatory breach allows you to treat the agreement of purchase and sale, or really any contract, as at an end, as you would if they hadn't come up with money on the actual closing day. So what does this mean practically? Well, this means that if you are acting for the time is a healer. Time is always a healer. Time is a healer in negotiations. Time is a healer through crisis. And time is always usually on your side. If you are a buyer who is experiencing financial trouble, oftentimes it pays to buy time. And if you are a buyer or a buyer's agent, and you are saying to the other side, my client cannot come up with money as a negotiation strategy, then you may be actually putting your client in great jeopardy. Because if you say that in writing to someone and say, I'm telling you, my client will not come up with money, give me a reduction of $50,000. If you say that, then you're going to get a lawyer from a smarmy lawyer like myself. You're going to get a letter from a smarmy lawyer like myself that says, hey, I got your letter. You are clearly not going to be able to conclude the transaction. This is a breach that goes to the root of title. As a result, we are claiming anticipatory breach. We are relisting. We're seizing your deposit, yada, yada, yada. And I would point out to you that there is a world of difference between a letter that comes from you to the other side that says, hey, we are not going to be able to come up with $50,000 with the extra $50,000, give us a price reduction or else we walk, and a letter that says, we are having tremendous difficulty coming up with our $50,000. Would you consider an abatement of $50,000 to the purchase price? Why? Because in the second letter that I have just, or the second correspondence that I've just highlighted for you, I in no way did not say that they were not going to conclude. I just said that they were having difficulty doing it. And so really what this is about being artful in the way that you communicate, such that you do not allow a lawyer such as myself to trigger anticipatory breach clauses and get a client out of a contract in the middle. So there's quite a few times that you see anticipatory breach letters going between lawyers in a rising market. You may have a job loss, a purchaser is being relocated, a change of heart, or a title defect. That's not all that common, because usually in a rising market it means that, you know, by locking in 3 months earlier, you're getting a better value as it goes up, and usually people find their way through it. But anticipatory breach does definitely take place in a falling market, where a property is purchased and a purchaser is trying to sell their other property in order to afford it and can't. Where a purchaser's firm deal for the sale of their property falls apart happens. Where a purchaser overpays for their product. Where a purchaser becomes fearful of market conditions. God, we all saw that with COVID. Where property doesn't appraise property properly. We saw that with COVID. All of those reasons mean that a purchaser may very well say, I'm sorry, there's nothing I can do. I need to walk. Now, sometimes the purchaser gives you permission to actually write that letter. And sometimes there's good reason for that. After all, a purchaser is aware that they may lose their deposit, but they're also aware that they may lose more than their deposit. They may be liable for whatever the difference is between what the next party, the next purchaser, is going to pay and what they've paid. We're all aware of this. It's basic damages. But giving the seller 2 or 3 or even 4 months additional time to effect that sale by telling them that you are breaching early may in fact be in your interest, because you may be able to stem damages. And remember that there's nothing illegal about breaching an agreement of purchase and sale. You know, this is the thing that I don't think, I would suggest 99% of people on this forum do not get, maybe even the lawyers. There is nothing illegal about breaching an agreement, about breaching a contract. There's no illegality to that at all. It's a perfectly acceptable thing to do to breach a contract. It's a business decision. Yes, there are damages that flow from the deciding decision to breach, but there's no court that will sit there and find you morally wrong. There's no criminal law against breach. All there is damage repercussion, which is something that is perfectly acceptable for some people, should they choose to get out of a deal. Some people see it as a tactic in business, and that too is perfectly acceptable. Now, the interesting thing about anticipatory breach is that it happens a whole lot of times, and there's a whole bunch of case law that surrounds it. But the be-all and end-all is that normally, in order to put your client into a position where they can sue for damages, you have to effect what is called in law tender. Tender is when you actually provide all your documents or your money to the other side and say, here we go, my hands are clean, I've lived up to the agreement, you haven't lived up to yours, now I'm going to sue you. But tender is not required when the other party has clearly repudiated the agreement. And the other side does not need to wait until the date of performance in order to commence proceedings for the damages. And as a result, the case law has made it that anticipatory breach letters give you all the rights that an aggrieved seller would have had someone not come up with money on the day of closing, should your lawyer protect your seller's interests prior to that time by claiming anticipatory breach. When you claim anticipatory breach, you have four different options available. Three that I'm going to talk about here and one on the next slide. One is rescission of the contract. Court can, if you say, look, here it is, they breached, you can say to the court, get me out of this contract. The court can say, okay, we're removing the contract. Two, you can get damages. And we talked about what the damages are before, but the difference between the property of after relisting and selling, the interest on the purchase price, the mortgage, carrying costs, lawyer fees, losses. You will not be given damages for emotional distress or aggravation. The amount of time that people come up and say, oh, we're going to sue for the emotional stress, you have no idea what this has done to me, is every time an agreement of purchase, someone engages in a lawsuit, but you're never going to be successful in that. This is just basic business and you're breaching the agreement, and it isn't likely that you'd be able to get anything other than the damages listed above, or you can get specific performance where the court can order a client to perform its contract. Now, that usually doesn't happen in a buyer's situation, but it does happen if the seller breaches. I once acted for someone who was selling a home in Forest Hill, a very unique product, and she decided that she would back out of the deal after she had signed it. And the purchasers brought an action for specific performance and said, look, you're breaching in advance. They said, you're breaching this agreement. You've told us that you want out. Well, we aren't letting you out. We want your house, and we are going to get a court to award it. And indeed, that threat was enough to make them back down because the purchasers were completely right at law. Of course, you also can lose your deposit. I'm not going to go into this too much, but because Brian Madigan did an amazing talk on this about what the loss of deposit means and everything else. But in Tang and Zhang, which is really the leading case on this, deposits are seen as liquidated damages, which are in addition to any other damages that are being claimed. And so generally, if a purchaser is walking away on an anticipatory basis, the only thing I've ever really seen is someone bring an action for rescission plus the deposits to be forwarded to them, assuming that they are forced to go to court in the first place. As we are aware, under Section 27 of the Real Estate and Business Brokers Act, or as it's now called, TRESA, the Trust and Real Estate Services Act, the brokerage is only permitted to release in the event of completion of court order or a mutual release. And most people do arrange for mutual releases if the purchaser is in fact walking, because most lawyers are able to tell them they don't have a leg to stand on. Why go to court about this? It doesn't really make that much sense. Someone has just written something which strangely, there we go. Gene, take care. Okay, next. And last. So what other options do you have if you are acting for the purchaser other than anticipatory breach? Well, I'm bringing this up because we are entering into strange times. COVID has put us into strange times, particularly if you function in the commercial space. Most of us who have been around for 10 years have never really had to do the work of real estate agents of the past. That is to say, thinking up other ways of actually making an agreement of purchase and sale come together. Usually what we say is, I want you to go ahead and get your mortgage and then pay me money, and that's it. And the problem is that if a lot of deals start falling through, sellers get wary of putting it back on the market because after all, they'll be back into the same position with another purchaser who can't get financing or anything else. And as a result, there are any number of things that are done at a lawyer's office in order to deal with anticipatory breach when the party who was claiming anticipatory breach doesn't want the deal to fall apart. One is to extend the closing date, that's obvious, but that doesn't necessarily always help. Two is a vendor take-back mortgage. You know, it occurs to me in dealing with a lot of people that people are very intimidated by vendor take-back mortgages, and they don't understand what it means. And even though it's right in the word, what it means is that the seller is taking back a second mortgage for an amount of money. So, for instance, if you're agreeing to pay $1 million for a property, and a bank is ready to extend $800,000, and all you have is $100,000 in your bank account, then you get the vendor, the seller, to extend a $100,000 mortgage, which you will pay on top of the $800,000 mortgage. You'll pay $800,000 back to the first bank, and you'll pay $100,000 over to the seller. And all you really need to do is extend a clause similar to the one I have here, and your lawyers will work it out. It's not for you to do. The lawyers will work out that mortgage. And that's actually a pretty easy thing to do. And it's a nice way of achieving financing because after all, the seller has the same interest as you do, particularly in a falling market. The seller may very well just basically offer this because they know that purchasers just can't get the financing necessary to do this. Another thing that I've seen done, although it's been decades since I've seen it, is convert the agreement of purchase and sale into an agreement to lease with an option to purchase. And what that means is that you're effectively paying leasehold amounts, a portion of which goes towards the deposit, and it crystallizes at a particular time to become an agreement of purchase and sale. We used to have a specific form for that. It's no longer on web forms, but if you ever are in that circumstance, speak to a lawyer. It's pretty easy for us to draft something like this, and it's another option available to someone who's trying to string together or keep a deal going when a purchaser has claimed anticipatory breach. Or, of course, purchaser can rent property under an occupancy license until such time as 6 months, a year has passed, still being bound by an agreement of purchase and sale that's due in, say, a year's time, just to give whatever the offending problem is time to recover. So guys, that's it today. I told you it was a refresher course, and it was going to be kind of a bit of a quick one. But both of these issues are issues you should know. David points out rightly, by the way, with regards to the financing, the vendor take-back financing, that secondary financing is often not allowed by our first lenders. And as a result, we see less and less VTBs. That's absolutely the case. More importantly, you should be aware that any VTB that you do will be shown to a lender and has to be disclosed to that lender by the lawyer regardless, for sure. Remember, the lender is going to request to see a copy of the agreement of purchase and sale, and of course, the VTB language will be there. So what you can do as a real estate agent is simply make it conditional upon securing VTB financing and having that be acceptable to the first mortgagee. And there is a line actually in web forms that pertains to that, but certainly if you can't find it, I'm happy to help you with that as well, as is David. Any questions for me, guys? I know it's been a bit of a smaller group today. I know it's been a bit of a quicker chat, but the stuff on good faith is important. Stuff on anticipatory breach from your perspective, ensuring that you never trigger that on behalf of your clients inadvertently, and you're always using words like we're having trouble, we anticipate having trouble closing, as opposed to saying we are having trouble closing. Actually, you don't want to say we anticipate having trouble closing. You want to say we are worried. We are working hard, but we have concerns about closing, so on and so forth. You want that language to be couched such that anticipatory breach can't be claimed and all the ramifications that we discussed today flow. But other than that, does anyone have any questions for me before I hit my dentist appointment?
Perfect. Thank you.
Okay, guys. Well, thank you very much, as always. I'm glad that we did this. I'm glad that we've all taken a look at good faith. It's very important, and I'm looking forward to see how it evolves in the coming years, and I'll certainly give updates accordingly. I wish you guys all a great day, and yeah, thank you very much.